Thank you so much. Each IP has a registration process. When it comes to copyright is being regulated or being controlled by the Nigerian Copyright Commission, which is the NCC. And like I mentioned, we don't really call copyright registration because the law provides that copyright doesn't require registration. So it's more like a deposition of your work. So yes, the best way to get your work deposited or to notify NCC is by getting an IP lawyer, an IP agent who is into intellectual property, because most times people just say they are into IP, but at the end of the day, they really do not understand the process. And once you are working with an IP person who is not an expert, you might have issues with registering the right class or registering, things like that might happen. So you have to get an IP expert to do your registration for you. With copyright, I said it lasts throughout the lifetime of the author and 70 years after the death of the author. So for copyright doesn't require renewal. You can't renew copyright. Once your 70 years after the death of the author is over, then it's over. It is patent, trademark, industrial design that requires renewal every year up to the point of their deadline. Like patent is 20 years. Once that 20 years is complete, it goes to the public domain and you can't renew it any longer. Okay, so that question is kind of dicey, but I'll give you exposed to that question because IP rights or protecting your IP can be expensive, even though what we charge in Nigeria might not be as expensive as what we charge abroad, but protection of IP right can be expensive. So what I advise is, as a creative, you don't know which one will work. You don't know the day your creative activity is going to blow. So you can't say that, oh, this is the one that is going to blow. But I think while you are going through the creative process, there is a way you kind of see some signs that tells you that, oh, I think this one is likely going to make wave, right? So doing that, you might decide to now want to protect that particular one. Another option I like to say is, because if you have about 5 or 10 prospective works that are going to blow, do you have to register those ones individually? So the expo or the shortcut is that you put all this work in a Word document, like all the creative write-up. You put everything in a Word document and you register or you deposit that work as a Word document. Not you doing it protect one, but it only works for copyright, actually, only copyright, because it's a literary work. So you can just do it like volume 1, volume 2, volume 3, but they are all in a Word document. So is that particular Word document you are going to protect? But the question is, how long do you wait to write all these things? What if somebody else is already done something similar before you go ahead? So there's no straight answer, honestly. You just have to follow your guts and do it. When you work for an organization, you have to understand the rules, the regulation, the IP framework or the IP policy of that institution or organization. Because in most cases, your work is owned by the organization. That's in most cases. But if it's like maybe a school that you just come, you learn, and at the end of the day, you work on a project, the project should be something that you own at the end of the day. But like you said, so now you as the writer, you own the copyright to the script you have written. Also as a director, you own the, should I say, the movie or whatever comes out from it at the end of the day. But the issue is people don't understand IP. Someone that doesn't understand IP even if they sign non-disclosure agreement that you are going to carry them to jail, they still won't understand, because they don't understand what IP is. They don't know what, they don't feel what you are feeling. They don't understand what you've gone through to be able to do all of this. And this is why I say that whenever someone infringes on your rights, even if you will not take the person to court, or even if you will not get damages at the end of the day, one thing you must do is you must call that person out. Because you calling that person out means there are so many people that is going to learn from that person's experience. So take, for example, the viral video that has been going out for this Kumbi skin. I'm sure thousands of people have learned from that situation, and they are going to implement that in their own business as well. But when you leave cases and say, okay, I leave it to God, or I let it lie, it will continue happening, because people won't learn. They won't know that they've done something. So this guy now, he might not see anything wrong in what he did. He doesn't understand that there's something called intellectual property rights, or there's copyright. So you, as the creator or as the writer, you should have probably even at least try to fight for your right. And this is where enforcement comes in. Like I said, copyright is the type of right that you don't necessarily need to register it. The moment you've written it and you've worked on something original and you have it documented, then you have right over it. You can fight for it, whether you register it or you don't register it. You can fight for it. So if you have gone a step further to fight for it, they would have said, okay, come, let's see how we can manage, and probably let's give you a particular share from whatever proceed we make from this. But because of you kept quiet, they will also still make that same mistake with somebody else, because they didn't learn anything. They didn't know what they have done. So as for you, when you are working with people, even as organization, your staffs need to understand the IP policy of your company. Because let's say a graphic designer is working for a company, and a graphic designer has done something that is very nice that the company is benefiting from. That graphic designer, because he was the one that worked on that graphics, when he's leaving that company, he will want to use that graphic design to make profit, or say give somebody else, because he designed it. But the graphic designer will not understand that, because he was under job employment, and the description of his job says he has to design graphics for the organization, meaning that whatever he does belongs to the organization and not him. If we go ahead to use that design without the organization's permission, and at the end of the day, he's going to be facing lawsuits. But if the organization did not even make their staffs to understand IP rights, what do you own? What does the organization own? People will continue making mistakes. So you, as the director, you need to let people understand IP rights. Be clear to them that, oh, this thing we are doing, because I'm the one that wrote this and this, I have copyright over it, and you don't have the right to do this and that. People need to understand. You are able to talk about it because you've seen the benefit of IP and how IP can protect you. But someone that doesn't understand intellectual property will not think in that light. Do you understand? So going forward, IP education is important. People don't know. You have to say it and say it and say it. Give them cases. And another thing you can do is let them see that even if you are doing this work as a joint work, because like you mentioned, you were doing the script, he was probably doing another aspect. You can have a joint work. And when it is joint work, it means you both own the copyright. And whenever you are exploiting that work, the both of you are going to have benefits from whatever it is you make. So even it's just basically understanding. And like you said, you put in NDA and all, but they also need to understand the consequence of not following that NDA, and you have to follow up. Because if you put in NDA and they decide to disclose your copyright or your secrets, but you did not follow up with it, so what's the assurance that next time they won't do the same thing? Once a work has entered public domain, you are free to use it. Like, you can use it anyhow you like. So you don't need permission or anything. But what you can do to probably get a right on a work that's already in public domain is you do something creative. So let's say maybe Mickey Mouse now. Every 1st of January, copyright enters into public domain in the US. So the Mickey Mouse character is no longer protected. It's now in the public domain. So let's say there is something else as a creative that you can do to make Mickey Mouse a different, or to give it a different outlook, something that makes it different from the entire Mickey Mouse that we always know, then you can have a protection for something like that. As long as it's not a copy and paste work, you will definitely have protection. Let me see another example. Okay, let's say, for example, this song, Happy Birthday to You, it used to be in, I think it used to be copyrighted, but I think now the copyright has expired. It means as any musician can sing that song, you can sample it, you can interpolate it without any permission, and you won't be infringing anybody's right because the work has already expired. But if it has not expired, what you have to do is to get permission before you can use it. And even the law says that because of you've infringed on a work does not mean you don't have copyright over your own work. But you will need to clear that infringement, because if you don't clear that infringement can lead to probably DSPs taking down your own work. So consent is very important, authorization is important, but as long as the work is in the public domain, you don't need consent, you don't need permission, you can use it for whatever it is you like. The only question is, how do you know that it's in the public domain? You have to start calculating the number of years, the protection period, to see if really it's in the public domain, or you probably ask around. Copyright, like I said, doesn't require registration. So if you have copyright protection over an artistic or a literary work, like because of you have that automatic protection, and someone is using it without your permission, yes, you can fight for it. Why? Because copyright doesn't require registration. Even if we say it's possible for you to deposit your work. But if your work is not original to you, then it means you don't have copyright protection. But for other work that says that you must register, for example, patents, if you don't have a patent right to an invention, you cannot sue somebody for using it because it's not even yours in the first place. The only thing that will give you that exclusive right that it is yours is when you register the invention as a patent. But for trademark also has the side of unregistered and registered rights. So for example, you've been using a brand name for, let's say, 10 years and you haven't registered it, but somebody else goes ahead to register it before you. In that case, because of you have not registered it, you won't call it an infringement. It's likely to be a passing off, not an infringement, because the person is trying to pass off your brand or bootleg to benefit from the goodwill of your brand. In that case, you can actually fight for it, but to be under the common law of passing off. But you have to show that truly this person, there's confusion, the person is misleading, the person is diverting your fund. It's so much process. So the best bet is for you to have things like that registered. But for copyright, as long as your protection period is still on, you can definitely fight for copyright, since you have everything to show that truly you own it.